Thanks so much, Jennifer, and welcome everyone to the 5th annual Data Privacy Conference hosted by both LinkedIn and the National Cybersecurity Alliance. We are so happy to have all of you here with us today. And for so many of us, the events of these past 2 years have underlined the necessity for data privacy protection and awareness in a big way. So much so that we decided to make Data Privacy Day into an entire week of events in order to give the topic the attention it needs. I hope that you've had the opportunity to take advantage of some of those events, and we're so glad to have you join us today in this discussion from privacy experts in industry, government, academia, and the nonprofit sector as well, to help us bring a greater focus into just a few of the many topics we're grappling with in privacy today. You're going to hear this morning about online tracking, privacy awareness trainings, data collection for diversity and inclusive initiatives. And now we'll kick it off with our two first speakers to lead us through a discussion of the current state of privacy. So please join me in welcoming Julie Brill, Corporate Vice President, Chief Privacy Officer, and Deputy General Counsel of Microsoft, and FTC Commissioner Noah Joshua Phillips. Thank you.
Thank you so much, Kalinda. And hello, Commissioner Phillips. It's lovely to see you.
Hi, Julie. It's great to be here with you.
So first, why don't we thank the National Cybersecurity Alliance, as well as LinkedIn, for bringing this entire event together, and actually for bringing you and I together to have this discussion about what is happening in privacy in the United States and around the globe. So I'm really honored to be here with you. And as a quick introduction for everybody who may be listening, I am Julie Brill, as Kalinda said. I'm Microsoft's Chief Privacy Officer and Corporate Vice President for Global Privacy and Regulatory Affairs. Prior to my role at Microsoft, I served as a commissioner of the U.S. Federal Trade Commission for 6 years, where I worked on issues of critical importance to consumers, including privacy, fair advertising practices, financial fraud, and competition. With that, let me introduce Commissioner Phillips. President Donald Trump nominated Noah Joshua Phillips to be a commissioner on the Federal Trade Commission, and he was confirmed unanimously in April 2018 by the U.S. Senate. Before coming to the FTC, Noah served as chief counsel to U.S. Senator John Cornyn of Texas on the Senate Judiciary Committee. So with that, Noah, shall we dive in?
We absolutely shall, but I would be remiss if I didn't do two things. The first is just to thank you, Julie, thank Stay Safe Online and the National Cybersecurity Alliance. I'm really thrilled to be here, pleased at the invitation. And the second thing I'm supposed to do is tell everybody that I'm just expressing my own opinions and not necessarily those of the commission as a whole or my fellow trade commissioners.
Awesome. All right, let's first talk about the state of the issues before the commission now versus what they were when I was there. Some of the privacy issues that the FTC is facing today have been around for many years. When I think about data brokers, children's privacy, the relationship between competition and privacy, frankly, have been things that we were talking about when I was a commissioner, you are talking about now. And I'd be interested in your views about how long we will continue to be talking about those issues, perhaps forever. But there are new issues that I think are before your plate and before the plate of your fellow commissioners that weren't really on the radar screen, or certainly not at the center of the radar screen back when I was in the commission 2 administrations ago. Things like algorithms, bias and fairness in algorithmic decision-making. And I'd also say, to a certain extent, even the interplay between privacy and competition has come more to the fore now. It was an issue back then, but it is, I think, probably a bigger issue now. So I'd love to hear, and I think the audience would probably love to hear, how do you see these trends? What do you think about these perennial issues that have not yet been solved, as well as the ever-expanding aperture of the issues that are in front of the commission now?
Sure. Well, let me add answer that embedded question that you gave, which is when are we going to resolve these issues, or how long will these issues stay with us? Conversely, I think the answer to that is forever. I don't think we're going back. I think that there is a trend toward the utilization of more data about consumers by more and different kinds of businesses, and that has a multiplier effect over time. So I think we are adding issues. I don't know that we are really subtracting them, at least when privacy or where privacy or cybersecurity are concerned. You know, one of the great things about what we do at FTC is that we have sort of timeless principles that we apply to new technologies, right? So whether you're looking at data brokers in 2014 or you're looking at algorithms in 2020 or 2021, I guess we're in 22 now, what you're looking at is the question of deception and unfairness. And these were by design, by Congress's design, supposed to be kind of immutable principles that could be broadly applied to business practices, even with changing technology. And in the course of, an almost 100-year, almost century-old consumer protection jurisdiction for the FTC, ever since the 30s, that's what we've done. And that's how, as you well know, we got into the privacy business in the first place. So one thing is the application of timeless principles to new technologies. That's thing number one. Thing number two, you were talking about the aperture, and I think you're absolutely right. I think there is a broader conversation about what kinds of harms people are going to take as being privacy harms. There is also a debate about whether they are harms, right? So what level of distinction in how ads are targeted amounts to a harm, right? We've seen a rebranding going on in the last few years where there are some people who, instead of calling something, targeted or behavioral advertising, now say surveillance, right? And as far as I can tell, we're describing the same business conduct, but we're applying a pejorative. So I think there's a growing conversation about the kinds of harm we might see. You mentioned competition. I think there are some who view privacy and competition as necessarily linked. I tend to take the under on that bet. My view is that they are sometimes linked, but oftentimes they work at cross purposes. But actually, I think one of the biggest areas to watch, at least in privacy enforcement, over the next few years, is the question of remedies. What the FTC can do and what it tries to do and what it ends up doing in terms of addressing the harms that we see. And I think you see two trends, and I think they're headed at each other at a very high speed. So one is a trend of rhetoric that we need to be doing more. We need to get more money. We need to name more executives. We need to require you to get rid of the algorithm that you use with your ill-gotten data. On the other side, what we see is a court system, right? The Supreme Court 9-0 issuing the AMG decision and saying that we can't get monetary relief on Section 13B. That's a real check on our authority as practiced for decades. And I think one response will be to look at other areas of authority, right? Where are there penalties available? Or can we get money under Section 19, which is a different statute or different part of the statute? And one of the effects that I think is having already, and you see it in the context of health breach notification, you see it in the context of Section 19 in resident home, is that because we have authority that's going away over here, we're getting very creative about authority elsewhere. And creativity is a good thing when you're doing art. It's a good thing when you're doing innovation. I'm not so sold on creativity in law enforcement. To my mind, the rule of law is better off when we have clear rules. And so I think that we're going to end up getting bad results, both for people in front of us, but also for consumers, if we try to expand a statutory authority beyond what it provides.
Super interesting. There's so much in that answer that I would love to debate with you. But I think what I'm going to do is pick up on one theme, your creativity theme. and apply that, if I may, to the area of legislation and rulemaking. Because, as you and I have talked about on many occasions, there has been an effort underway. This is another somewhat perennial issue, to adopt federal privacy legislation, whether in the relatively limited area of data breach notification or in the broader area of comprehensive privacy law. There are now some legislators who are actually calling for the FTC to issue rulemaking as a implied recognition that federal legislation may be more difficult to get over the finish line than they hope to be the case. And as we also know, there are members, your colleagues are talking about developing rulemaking and using a rulemaking process to adopt rules around privacy. Now, not everybody who's listening to this is as steeped in the administrative process as you and I are with respect to the FTC. So just at a very high level, I'll mention that the process that the agency will need to use is not a streamlined process. It is long and can be cumbersome. And it is known as the Magnuson-Moss rulemaking process. What I'm interested in talking about, of course, interested in talking about anything you want to say with respect to Mag-Moss versus the more streamlined process under the Administrative Procedures Act. But I'd be interested in your view also substantively about the challenges that you think the agency is going to have in terms of rulemaking, and how will the agency try to overcome them? And then what is your prognosis about this effort? Where will it go? And what should companies be looking out for? Now, that's a lot that I threw into that one question. So take whichever pieces you want, and I'll make sure to do some follow-up.
Sure. Let me start with the end and then hopefully come back to the end at the end. I think, what should companies be doing? When the FTC opens any public process, right, commenting on a rule, we're looking at merger guidelines right now, I think it is imperative for all stakeholders, that's civil society groups, but also companies, to participate, right? So I think whenever we have a process, a policy issue that is going to bear on any interest, I want to hear from more people because I want to get the best data. I want to know the impact of the thing we're going to do because that's how we're going to make, I hope, the best decisions. So let me talk about privacy rulemaking. A couple of points. The first point is privacy is a capacious term. And as we were talking about just a moment ago, what people are now considering privacy issues is broadening with time. It isn't narrowing. So when you talk about either legislating or rulemaking on privacy, one thing that I think we owe the public, one thing that I think we are going to need is focus. We're going to have to say, this is a privacy thing we're interested in doing, and this is not. I'll get into the legal test in a moment, but I think it's really important that we recognize as we talk about privacy that sometimes people are talking about different issues, right? Sometimes people are viewing the same conduct either as beneficial or harmful. My dad, I always say this, but it's really true. My dad loves to see the ads based on his emails in Gmail. Some people find that creepy. What you do with that, right? Is that a harm? Is it a benefit? How you weigh the two, I think, is a terrifically difficult kind of public policy question. And it is for that reason that my view is that it's Congress that ought to make these big value judgments. There are real trade-offs when you're talking about privacy. And the best place to do that is the legislative process, not in administrative rulemaking. You are right. The Magnuson-Moss process is a long one. It involves extra layers of review. And when I say extra, I mean more than you would see in a normal administrative rulemaking process. And part of the reason for that is that the scope of the authority is broad. But it's also really important to know that whatever we do in the Magnuson-Moss process, whatever we purport to regulate or ban, is going to have to fall into one of two buckets. It's either going to have to be deceptive or it's going to have to be unfair. And unfair isn't anything we want. Congress told us what unfair means. And to me, one of the most important things to watch, I think there are a lot of eggs of hope, right, if you will, in a basket about what the FTC can accomplish. There are people who have grand visions to how we will restructure society, and ban practices that are essentially endemic. And I don't know that the law bars all those things. So at the end of the day, the thing that will be the most important is that whatever we do, if we do this, whatever we purport to regulate, whatever we purport to ban, actually has to be illegal. And that is a much harder test to meet in the context of some of these bigger policy questions that we talk about when we talk about privacy.
So interesting. So do you have are there any aspects of the set of privacy norms that exist globally that you would like to see the agency pursue? So for instance, breach notification, solidifying that through rulemaking, data subject rights, where consumers, users would be given the ability to see their data, delete their data, et cetera. I understand that you may view those as, or some of those, on the edge of whether or not they would meet the legal tests that you're describing. But I'm wondering if you could wave your magic wand, what would be the issues that you would want to see discussed, at least, in terms of rulemaking by the agency?
Sure. So let me put aside this prudential question of whether, when you're talking about these big, policy questions and you're weighing them, whether that ought to be done by the legislature or it ought to be done by, a majority of unelected bureaucrats like me. Putting that aside, one area I do think that cybersecurity, right, deserves a focus. When the Commerce Department did its study in 2018 of what people think about when they think about privacy, ID theft was the top of the list, right? People don't want bad guys having their data. They don't want their credit cards used. It sounds a little prosaic in a world of surveillance, but it's actually really important. Maybe we could do that separately. Another issue that strikes me, when I listen to when people describe what they're concerned about, it's a lot of, I don't know what's going on, right? And so I tend to think that actually nutrition labeling type ideas are really interesting, right? Is there a real problem in the market? Not just that people have to click through policies that aren't meaningful, but maybe they care more about privacy than they're showing us in their behavior, and maybe more information, right, getting to people to make decisions in a way that is digestible. Maybe that's a really important thing at which to look. I think, those are some areas that I think ought to be focuses. To be clear, first for Congress, but certainly if you're in a rulemaking context.
Interesting. The nutrition label idea, meaning essentially very simple and uniform disclosures that consumers and users get accustomed to seeing when they are looking on a website or going to a privacy page, wherever it may exist, so that they gain a simple understanding of how their data is being used, what their options are, how they can opt out, et cetera.
Right. So, what we have in Europe with GDPR is you get more pop-ups, and maybe you get to toggle with the cookies, and you get these long disclosures. And it would be terrifically inefficient for everyone if everyone were to read them. But even for the people whose job it is to focus and spot some of the wrongdoers, people who are misrepresenting and so forth, still terrifically inefficient. Nutrition labels are an example of where you have great complexity in the underlying process, but we have a standard system, like you said, a uniform system where for those consumers who care, and that's not all consumers, they have an easy referent. What are you doing? Are you selling the data? Are you sharing the data? Are you predicating ad sales on the data? What is your policy vis-a-vis national security or criminal authorities? Some of the issues that people talk about, but answering the question, what are you doing with my data? I think that's a critical area for potential improvement.
So we talked a little bit before, or at least mentioned this idea that the overlap and really interplay of privacy and competition is coming more to the fore and being discussed quite a bit by some of your colleagues, as well as many people who are thinking about the right approach to some of these issues with respect to particular practices and particular kinds of companies. So I'd be really interested, and I'm sure our listeners would be really interested in how you're thinking about this conversation, its evolution over the past several years, and how the FTC should be thinking from your perspective about the relationship between competition and privacy.
Sure. So let me start with just a basic idea. The basic idea is the following. What we are protecting when we do competition law, when we do antitrust enforcement, is markets working, right? Assets moving around, freedom to operate. And what we guard against are, just to borrow from an 1890 statute, the Sherman Act, restraints of trade, things that limit commerce from happening. When we talk about privacy, fundamentally, we're talking about limiting access to certain kinds of information about people. And I think one of the things we have to concede when we look at the modern economy is there is a lot of commerce to be made from utilizing information about people. Literally trillions of dollars in economic activity centered around that. So where privacy is trying to sort of limit the spread, limit the utilization of the asset, competition may favor opening up access. And so to me, there is a fundamental tension that inheres between the concepts. It's not always true. So if we were looking at how do two companies compete and they want to merge and cancel out that competition, we might look at price competition. We might look at quality competition. And if they were competing on privacy and we saw that eliminating that competition would really lessen competition in the market about privacy. I give the example of Alphabet, which is Google's parent, buying DuckDuckGo, which is competing on privacy. I think that's something at which we ought to look. But I think the incidence where the two align is dramatically overstated. And the remedies, the laws that apply, the remedies that you use to solve each problem often work in the opposite direction. We've seen this theme talked about. It's usually talked about in the context of big tech. And okay, we can't spot a price harm, but maybe we can spot a quality harm in the lessening of privacy. But the question is competition the thing that would yield the privacy? And I would argue the answer is mostly no. And here's why. Two things. First of all, a lot of the privacy harms that we see aren't big companies with any discernible market power. So take two really important privacy cases that we've brought during my tenure, Retina X and SpyPhone. These are stalking app cases. These are bad people. And they're doing something that can really, really hurt people. I mean, even endanger lives. These aren't monopolists. They're not giant companies. There's no way these guys have market power, but they're still violating privacy. The same principle, by the way, holds true with fraud. It's not just an outcome of market power. It can happen even for small guys. And that's a really, really important thing to take into account. The second thing is, if you think that privacy is the natural result of the free market operating without constraints, then your argument for regulation, your argument for rules or legislation goes away. Solve the competitive problems and you'll get the privacy you want. I don't think that that's what we've seen. And I think that is precisely why we need to be thinking about intervening in the context of legislation. The argument for it is because privacy isn't a natural externality of free market forces. It vindicates other values that we want. And I think it's important to understand that in competition law, what we're protecting is the natural outcome of market forces.
So this is such an interesting perspective. And of course, your fellow commissioners feel differently about this.
They do.
And it will be very interesting to see how some of these issues get resolved. One of the things that I always really appreciated about the FTC when I was, there and in your seat, was that you could have pretty disparate philosophical perspectives on issues, and at the same time agree on cases. Because what often came before the agency, as you pointed out a moment ago, were cases that did represent broader principles, but also were focused on particular actions by particular players in a particular context. And it really is fascinating how people with very disparate ideas have been able to come together on so many cases over the many years that the FTC has been in existence.
Yeah. I mean, my view is, well, let me say two things. The first is that there are some timeless principles that apply. There are lots of edge cases, but I think everyone is interested in applying those principles to, markets as they develop, to new technologies and this sort of thing. The other thing is this. I think if we're doing our jobs right, part of what we're focusing on, if not most of what we're focusing on, is where is the most harm caused? And a lot of the cases, and you know this from your experience, but a lot of the cases we see, including in privacy, are bad cases, right? People are doing something that is harmful or clearly a violation of the statute, where maybe there's less harm threatened, but the rule from Congress is more clear. I want harm to continue to rule the day. I don't want us to neglect where people are really being hurt just because there's a target we have in mind, right? Or a company that someone doesn't like. Sometimes companies that a lot of people don't like are doing wrong, but sometimes it's companies no one has ever heard of, and they're doing wrong too. And I think where we do that, it's a lot easier to find common ground.
Well, terrific. Thank you so much for sharing your thoughts and your perspective on all of these really critical issues that are facing, frankly, all of us in terms of the path forward for data protection and privacy. And what a great day to be talking about this. So, Commissioner Phillips, thanks so much again. And I'll turn the program back over to the organizers. So thanks so much, everybody.
Thank you, Julie.